Good morning. Welcome, everyone, to the American Enterprise Institute. And it's exciting to see like a full room. We love intern season. It's just great to have you all here. I hope you're having a great time here in Washington, D.C., enjoying the heat. And this is, part of the fun of being in Washington is getting to see these experts live. I know that a lot of you probably watch these things on YouTube, which we're on YouTube as well, when you're doing classes. But please take advantage of the fact that you have them here, and I'm expecting you all to ask really good questions. So at the end, we have mic runners who will come over to hear what you have to think about this great panel. So we are here today to discuss the evolving. Let's use the right word. Let's make sure that we do that right. The evolving legal landscape surrounding online free expression. This year, the Supreme Court has taken up several landmark cases that are redefining the relationship between government authority and digital platforms. One of the most closely watched cases involves a Texas law mandating age verification and warning labels on adult websites, raising profound constitutional questions about free speech, access to lawful content, and the extent to which the government can impose restrictions in the name of protecting minors. Today's panel will examine these decisions aligned with the broader trend of regulatory efforts targeting online content. They explore implications of the Supreme Court's 2025 ruling upholding the TikTok ban, considering its ripple effects on the speech and platform governance, the access of whether growing pressure from agencies like the Federal Communications Commission and the Federal Trade Commission could spark a new wave of government influence in what some are calling potential jawboning sequel to Murphy versus Missouri. We are fortunate to have with us a distinguished group of experts to unpack these developments and what they mean for the future of free expression online. So today, we are joined, I'm going to do this out of order in here, so Corbin Barthold is the Internet Policy Counsel for Tech Freedom. He serves as Tech Freedom's Internet Policy Counsel and Director of Appellate Litigation, focusing on tech policy and administrative law cases. He has extensive federal court experience, including clerkships and partnerships at major litigation firms before transitioning into public interest work. His educational background spans from being at law school at UC Berkeley, economics at the London School of Economics, and liberal arts at UC San Diego. Daniel Lyons, who is a fellow colleague of mine here at the American Enterprise Institute, as a non-resident senior fellow, holds dual roles, not only as an AEI non-resident senior fellow in telecommunications and internet regulation, but he also is the dean and professor at Boston College of Law School. And I know all of those students are very lucky to have you, and we are too. Daniel, always good to see you in person. He combines practical legal experience with top-tier firms and academic scholarship. He frequently publishes in legal journals and is very popular with the press. Regular media commentators on tech policy issues. You'll hear him on Bloomberg Radio, C-SPAN, and other major outlets. And Kate, we're glad to have you back. Last time you were here as part of Penn last year, and so now she is with the Center on Democracy and Technology, where she is the head of their free expression program. She leads advocacy on how speech protection benefits marginalized communities and civil rights interests. She has extensive policy experience spanning Wikipedia Foundation, the ACLU, PEN America, and the Congressional Research Service. Were you at the Congressional Research Service? I don't think I knew that. I was going to say, well, apparently my notes knew that. And she specializes in Section 230, which is very important to things like online privacy, content moderation, and combining legislative restrictions on expression, including book bans and educational gag orders that we're seeing today virtually. And then our moderator for today is my colleague, Clay Calvert, who's also a non-resident senior fellow here at the American Enterprise Institute. He is recognized as one of the foremost First Amendment law experts in over 150 published law journal articles on freedom of expression. He's a prolific author and commentator whose work appears on top law journals, popular media outlets, including CNN, Fortune, and Time. And we are very lucky that he is a regular writer here on AEI Todays, so you should always look for his work in this area. So I'm going to turn this event over to you, Clay.
Well, thank you very much, Shane. I appreciate it. And thank you all for coming here today. I just realized you're all here actually because you're concerned about TikTok. So At least we have a peg for why you're here. So we're going to have a great discussion today about two recent Supreme Court decisions affecting online First Amendment speech rights in tech policy, as well as a potential new case, as Shane suggested, involving so-called government jawboning, and a little bit about what's happened in the lower courts since the justices issued their ruling last year in a key content moderation editorial freedom case. And here's how we're going to proceed briefly as an overview. First up is going to be our discussion of the Supreme Court's 6-3 ruling on June 27 in the online age verification case of Free Speech Coalition versus Paxton. I'll tee up the case a little bit, and then I'll go to the panelists for their remarks. After we wrap up that discussion, we're going to do 3 more topics, 10 minutes each. The first will be TikTok versus Garland, in which the Supreme Court upheld against a First Amendment challenge and this is a mouthful, the name of the act, Protecting Americans from Foreign Adversary-Controlled Applications Act, foreign adversary in this case being China, and the application being TikTok. And then we're going to talk about what's happened since that decision as President Trump keeps extending these big, beautiful deadlines for China, either to divest itself from TikTok or ban U.S. companies from servicing it. And then we'll move into discussion about a potential new jawboning case against perhaps, and Corbin's going to discuss this, either the FTC, the Federal Trade Commission, or the FCC, the Federal Communications Commission, as the heads of those agencies pressure, or more perhaps accurately coerce, media companies to change their policies affecting content. And then we'll turn to Daniel at the end, and then we're going to have an update on what's happened with the Florida and Texas statutes that interfere with social media platforms' ability to moderate and curate content for themselves, since the Supreme Court ruled last year in Moody versus NetChoice. We'll save the final 15 minutes for any questions that you all might have and some quick closing comments from the panelists. So with that background in mind, let's dig into the court's 6-3 decision with the conservatives in the majority and the liberals in the dissent in Free Speech Coalition versus Paxton. So the majority applied the deferential standard of judicial review that we call intermediate scrutiny, and that was actually very important, to examine and uphold a Texas online age verification statute. Though that law requires websites and platforms that devote more than 1/3 of the material on their sites to sexual content that Texas deems harmful to minors. Harmful to minors is how they define it. And they do that to verify the ages. All of these websites have to verify the ages of everyone, all users, adults and minors, before they can access those sites. So importantly, sexual speech that's harmful to minors does not rise to the level of unprotected obscenity when viewed by adults. Adults have a constitutional right to access it. Yet the same speech is considered obscene and unlawful for minors. As Justice Thomas wrote for the majority, the speech is obscene to children, but not obscene to the public at large. Or as Thomas wrote in seemingly branding a new category of expression, it is partially protected speech. The Free Speech Coalition, a trade association for the adult entertainment industry, challenged this law for violating the First Amendment rights of adults to receive speech they have a constitutional right to view. Now, key arguments for the Free Speech Coalition were that the identity disclosing, age verifying requirements would create a deterrent or a chilling effect on adults who anonymously want to look at content they have a constitutional right to view, but nonetheless is stigmatized by many in society. Another chilling effect, self-censorship. They might not go to it because they got to disclose who they are. Additionally, the Free Speech Coalition emphasized that the personally identifiable information that will be gathered up in this age verifying process really creates a prime target for hackers, a honeypot of information for them. The Supreme Court majority, again, all conservatives, however, rejected those arguments, concluding the statute served an important interest in protecting minors from sexually explicit speech, and all the justices agreed there's an important interest in protecting minors. But they also said that the law only, quote, incidentally, unquote, burdens adults' First Amendment rights of access to material. And they also concluded that the age verification requirements are simply, quote, established, unquote, and ordinary and appropriate methods of protecting minors, such as they are for things like alcohol and cigarettes. The only difference, of course, being that alcohol and cigarettes are not First Amendment protected speech products. In sum, the majority held that that the government can force adults to disclose personal, age-verifying information in order to access sexual content they have a First Amendment right to view, but that's forbidden for minors. Or, as Robert Corn Revere of the Foundation for Individual Rights and Expression put it, the ruling limits American adults' access to only speech that is fit for children unless they show their papers first. That language about fit for children comes from a Supreme Court case called Butler versus Michigan. But again, the idea, you got to show your papers if you're an adult to get this content. So Justice Kagan penned a dissent joined by Justices Sotomayor and Jackson. They would have applied the rigorous strict scrutiny standard of review because it's clearly a content-based statute due to the nature of the law. It only applies to a specific type of subject matter, sexual speech. And also prior Supreme Court precedents in about 4 other cases involving similar laws that also applied strict scrutiny. And so the dissent would have sent the case back to the lower courts and said, okay, here's the correct standard, strict scrutiny, go apply it. With that in mind, let's turn to our panelists for their insights and their thoughts. Each person's going to go for about 8 minutes or so, 7, 8 minutes, and then we'll kind of break it down into a more informal discussion. So I will start, we'll go in order this time. I'll start with Kate to my immediate right.
Oh, okay.
Is that okay?
Of course, of course.
Right.
I am happy to go first. So I have a number of reactions to this opinion. First, the majority opinion, in my view, is, as Justice Kagan says in her dissent at one point, it is at war with itself. It very much wants to reach the result of upholding this law. And at one point in the opinion, it specifically says, well, we can't apply strict scrutiny, even though we've applied strict scrutiny to very similar, indeed, at one point, nearly the exact same attempt at restricting speech previously and applied strict scrutiny in those cases. We can't do it now, and we actually never would have, because we can make a few distinctions that we think justify applying intermediate scrutiny here. And the way it reads is, we can't apply strict scrutiny because we know the law would fail strict scrutiny, so we're gonna apply intermediate scrutiny and not rational basis, because we also acknowledge that there is some speech interest that is being restricted here, and that adults need to, and that adults are now burdened in accessing content that is constitutionally protected as to them. I think that this has the potential. I think that like this decision in general, finding that a law that has previously been subject to strict scrutiny is clearly content-based, would not survive strict scrutiny, but somehow we have come up with a way to say that because the speech at issue is partially protected in that it is not protected as to minors, but is protected as to adults, now gets intermediate scrutiny, could open the door to increased use of intermediate scrutiny to restrict, to content-based restrictions on speech. And I'm really concerned about that. I also think it could open the door and invites almost those who would want to restrict speech as it is delivered to minors or minors' access to speech to attempt to expand the definition of what is obscene as to minors to include more speech than what we've thought it includes so far. So the court says things like sexual content that is obscene as to minors. Well, what is sexual content? It can encompass a wide variety of things, including gay relationships or the existence of trans people, for example. It currently doesn't, but this decision invites the argument that content like that is sexual in nature and harmful to minors and therefore can be restricted or at least put behind an age verification wall. So those are some of my big concerns with the decision and what could happen after this decision, and what the arguments that I see coming from people who would like to restrict more speech or access to sexual speech going forward, or who would like to restrict access to basically any internet website at all. So for example, we have a couple bill proposals such as the Kids Online Safety Act or the Kids Off Social Media Act, which would prohibit kids under the age of 13 from accessing social media at all. I can see people who are pushing for those laws saying this decision gives us authority to, and this decision shows that these proposals are constitutional. On the other hand, I strongly disagree with that. I actually think that we can read this decision and should read this decision very narrowly to this particular context, to say that here the Supreme Court has held up a very specific age verification requirement to access speech that has always been said, rightly or wrongly, to be obscene as to minors and therefore unprotected as to minors. And that proposals such as the Kids Off Social Media Act or the Kids Online Safety Act or any other similar proposal that like California's Age Appropriate Design Code, all of those laws which would require age verification to access far more content remain unconstitutional, remain subject to strict scrutiny, and remain likely unconstitutional. And the decision actually does have a few indications in there that the justices might agree with that. So, for example, when Justice Thomas talks about how the court approached the Communications Decency Act, not Section 230 of the Communications Decency Act, but the rest of it when they struck it down, is to say that that law applied to far more content than content that is obscene as to minors. And that is one of the reasons that we struck it down. So I'm going to take that and I am going to run with it. Even so, like, all of my attempts to cabin this decision, and I will continue to think of ways that it should be narrowed and that the protections for people who have to use age verification going forward to be strengthened. It's still deeply concerning to have a content-based law, a clearly content-based law, subject to intermediate scrutiny and upheld, even when I think maybe it should have failed intermediate scrutiny as well, because there are, even under intermediate scrutiny, to me, significant tailoring issues in the law. For example, I don't even know what platforms it applies to. I don't know which platforms host only a third, or more than a third of content being content that is obscene as to minors, and the platforms don't know it either. So things like that are also concerning, because I also see a potential weakening of intermediate scrutiny in the application of this decision as well.
Well, thank you, Kate.
So
I think that's an excellent summary of all the issues. And can I just ask you one more question on that while we're at it before I go to Corbin? Are you suggesting kind of that the majority knew the result that it wanted to reach? It knew that strict scrutiny would not allow it to reach that result. It found a workaround and a deliberate dodge to apply intermediate scrutiny, and now that's going to make it easier for finding more dodges in other areas.
I mean, that's certainly what Justice Kagan thinks and says in her opinion, in her dissenting opinion. I can't speak for them. I am not in their brains. But when reading the discussion of why they can't apply strict scrutiny to this particular statute, that is part of what I see, that this was a results-driven, at least to some degree, decision, because they do want to allow the application of age verification requirements for access to this content. I would argue that and I think Justice Kagan argues that they could have done that. They could have given guidance for how to do that in a manner that survives strict scrutiny, but that's not what happened. There was a desire to uphold this particular statute.
Excellent. Corbin?
Thank you for having me, Clay. Thank you, AEI. Let's launch off of it being a pretty result-oriented decision. So there were several precedents that the court had to work its way around to get to this result. And I won't bore you for the moment with the details of those. What I will use that to say is that anytime the court is doing that, mischief is likely to follow. To ignore precedents that govern, you probably are going to have to break some things. And so I see a lot of young faces here. This gives me a good opportunity to do a little bit of First Amendment 101, or really what First Amendment 101 was until this decision started monkeying around with the dials. So one key rule under the First Amendment is the court should care whether the government is going after conduct or going after speech. So if the government wants to keep track of draft age males and makes them all carry a draft card, the government is not thinking in terms of free expression when it does that. It's trying to regulate conduct, keep track of people so they can call them up. Now, if a gentleman decides, hey, I'm going to burn my draft card in protest of the draft and the war, he has taken that rule and he's turned it into expression. And the court says, okay, well, the government didn't have expression in mind. It's a conduct rule, so it's kind of in the First Amendment, but we're going to treat that to lower scrutiny. It's expressive conduct. Whereas, if the government looks at adult content online and says, man, we really don't like that, we want to put barriers around it, the government is going straight at the speech. It's not a conduct rule, it's a speech rule. Well, no more. The court in this decision muddies that distinction. Another key First Amendment distinction, ban and burden. Actually, I should say non-distinction. The government banning speech and the government burdening speech is all one under First Amendment analysis. So one of the cases behind this case, for example, you had a rule saying that adult channels on television had to only show their content between 10 p.m. and 6 a.m. That's not a ban. They still get to show it. They still get to have their expression. It's a burden. They have to do it only during certain hours. The decision here says, well, this age gating requirement, it's not a ban, it's just a burden, and we're going to treat that like it matters, like it's a distinguishing factor. Again, that is not how this used to work until this decision. Protected speech versus unprotected speech. Until this decision, you were engaging in expression and the First Amendment was triggered, or you were not and it's not triggered. And there are different tiers of scrutiny as to how your speech might be protected, but at least whether we were in expression land or non-expression land, that was an up-down switch. Now, through this decision, we have some concept called partially protected speech. I have no idea what that is. I have no idea how that works. I had never heard of that before this decision. It's an entirely new thing. I find it kind of terrifying. How does it work? Stay tuned. Online expression versus offline expression. So under the First Amendment, until this decision, it was key that the First Amendment keeps up with new technologies. Just because we invent a new way to express ourselves, like video games, for example, doesn't mean that the First Amendment ignores it because it's new. It's kind of similar to the Second Amendment thing that we don't protect only muskets, right? Put that in the First Amendment, it's pretty intuitive. Not anymore. And Kate and I were talking about this before the decision. A deep cut. Justice Thomas uses a key line from one of the precedents affirming this rule I just told you about the First Amendment keeping up with new technologies. He plucked that line and tried to use it in this decision to say basically that if you have age verification offline, then you can have age verification online. And that distorts the point. The point is that if there are special burdens that are unique to online age verification, we need to take that into account so that the online speech is equally protected as the offline speech. That's how this rule should work. And then finally, we've been talking about these tiers of scrutiny, and I won't get deeply into this one. Maybe we can talk about it more. People's eyes tend to roll over when we get into tiers of scrutiny, but the TikTok decision does this as well, and now intermediate scrutiny versus rational basis review used to really be a big gulf. Rational basis review, pretty much anything goes. It has to be pretty harebrained for the court to strike it down. Intermediate scrutiny, it has teeth. The government really needs to think through whether it is tailoring its law so that it is not suppressing a whole bunch of speech unnecessarily or unnecessarily burdening speech. It doesn't need to be the least restrictive alternative like strict scrutiny, but it needs to be pretty careful. And now what we are seeing is that intermediate scrutiny actually means the government found a problem and it kind of roughly took aim at it, and it took some step that's vaguely related to its goal, and that's good enough. So a lot, we have a bit of a mess, and it's gonna be a long time before we know just how far these new rules go. But a lot to be concerned about.
That's a fantastic summary, I think, of constitutional law. It's really, for all of you who are kind of new to this area, it's a lot of dichotomies and a lot of categories, right? We can typically pin things into a category. The law is content-based. It singles out a particular topic. It's not content-based. It applies neutrally to everything. The online speech, offline speech, everything that you said really hit it. And I think, and you mentioned this, you tapped into this, there was a case called Ginsburg, which dealt with this in a bricks and mortar context, really, which is important to understand. So there used to be things called adult bookstores. And adult bookstores, right, they sold dirty magazines. And in that case, it was much easier to determine who was an adult or who was a child coming in. You could, one, look at them and kind of get an idea. If not, you could simply flash your identification and say, I'm 18 and up, I'm here. Online, it's a lot different. But nonetheless, this principle that in the Brown versus Entertainment Merchants Association, the video game case, the Supreme Court made it clear that the First Amendment principles don't change just because a new technology comes along down the path, right? And I think that's the problem here, is the court is trying so hard to find a workaround from this rigorous strict scrutiny standard, and it does mean something. Intermediate, it's just squishy, as you were kind of suggesting, right? It's amorphous. You get a lot more wiggle room if you're the government. Your interest doesn't have to be as high. And so it's highly problematic, but everything you said, the 5 or 6 categories, they were spot on. So if you ever go to law school, just remember, it's very categorical and very it's this or that, it's this or that. And now the court has mushed all that and made it problematic. So I will turn to Daniel at this stage.
So on the tiers of scrutiny point, I think Justice Kagan's dissent definitely has the better of the argument, right? The majority is trying to present the Texas law as just a restriction on minors who don't have a First Amendment right to access this material that's obscene as to minors. But the law isn't requiring kids to produce ID before they can go on the site. It's requiring adults to produce ID before they can go on these sites, right? Maybe that's okay, maybe it's not, but it's definitely a condition on and therefore a direct regulation of adult speech on the basis of the content that the adults are trying to get access to. So under very basic First Amendment rules, this should have been a strict scrutiny case. I agree with that. And yeah, Thomas's opinion feels a little bit like goal seeking, right? There's this, those who use Excel, right? There used to be, so I was a consultant before I was a lawyer. And when you're a consultant, sometimes you just want to make the formula fit the data, right? So you get the outcome you want and you use this function called goal seek and it produces the formula that gets you to the outcome you want. This is
Unlike
basically
lawyers who never do that.
No, absolutely not. Absolutely not. Right. Pick 2 points and draw a line. Sometimes you can pick 1 point and draw a line as long as you have a good argument as to why it curves the way it does. This is really an exercise in goal seeking, and honestly, I think Justice Thomas gets very close to saying that at one point, right? That the state ought to be able to do this. If we apply strict scrutiny, the state can't do this. Therefore, strict scrutiny cannot apply here, which is exactly backwards. But it's an indictment, I think, a little bit of how difficult it is to meet strict scrutiny, right? So. Just like in rational basis review, anything's going to pass rational basis review because the judge has to just think of a plausible reason why the legislator would have done this thing, right? Everything fails strict scrutiny because under the least restrictive means analysis, if the judge can imagine some possible thing the legislator could have done instead of this, and if the legislator didn't explain why they didn't do this instead, or how this thing would have been more burdensome for speech or not less burdensome, then the statute fails. And this is one of the things that's always frustrated me about Ashcroft, which is the 2005 case that this case is overturning without saying it's overturning. It was also an age verification case, and the court said, well, why didn't you consider just filtering software, putting filtering software on all computers, because that would potentially prevent kids from accessing this material, but in a way that's a little bit less intrusive on adult speech. And so the justice sort of imagined, what if we had infinite amount of money that we could install filtering on everybody's software all over the country? That's not the way that legislatures work. And so the Ashcroft has always kind of sat a little bit funny with me for that reason, that the least restrictive means analysis is actually really hard to meet. I think Justice Thomas says somewhere that the Holder v. Humanitarian Law Project is the only time the Supreme Court's ever upheld a First Amendment case under strict scrutiny. I found that really surprising. So 3 kind of detailed observations and a couple of quick hits. One, riffing on this technology point, right? I think it's super interesting that the state of technology can define the distinction between what's constitutional and what's unconstitutional, and that as technology evolves, it means the constitutional line moves. The court has said this pretty clearly in the Fourth Amendment context in Kylo v. United States, which is this case about whether police can use heat sensors to look inside houses to see if you're growing marijuana back in the days when that was illegal. And the court said no, because it's not a technology that's available to the public. But if it's at some point this technology would become available to the public, in which case it would be constitutional for the police to use it. There's a sense in which I think this case is the pornography equivalent of Kylo. because one of the reasons why Reno and Ashcroft said age verification was problematic was because at the time it was really expensive and it was really ineffective. It could be ineffectual. And so the theory was, if the only way you could defend yourself as a host is to use age verification, but it's really expensive, then you're really just going to not put up questionable content, and it's going to have a chilling effect. And so the court goes out of its way here to say in numerous instances, age verification is a thing now. Lots of e-commerce sites use it. And therefore, it's not, it doesn't say this, but it's hinting at it, right? Therefore, it's not as chilling of a requirement as it was 20 years ago with Ashcroft. Secondly, I think my sense is that the dialogue between Ashcroft and this Paxton case, I think, is really interesting because Paxton ignores or minimizes most of the concepts that were animating Ashcroft. So they ignore the fact that, so Ashcroft makes a big deal about requiring adults to produce identification has a chilling effect on what adults produce because adults are more likely to consume pornography anonymously than to create a record that ties their name to whatever their sexual preferences are in ways that might risk discovery in the future. This case blows right over that. So you have no right to, we've never said you have adults have a right to access pornography without producing age. And that's clearly wrong because that's exactly what Reno and Ashcroft were saying. It elides over the strong sense in Ashcroft, which comes through in Brown v. Merchants Association, the violent video games case too, that we as a society try to put tools in the hands of parents, right? We require parents to protect kids, and that's the first line of defense. And Brennan used to make a lot of hay on the idea that, lo and behold, there are some parents who actually think it's good to expose their children to stuff that society thinks is bad, and we should allow parents the ability to do that. This is an opinion that puts the state squarely in loco parentis, right? Kids should not have this material, and therefore Texas can do exactly what it needs to do to make sure that doesn't happen. No nod to parents at all. And there's no discussion of filtering, right? So Ashcroft is like, well, maybe filtering is more effective. This opinion doesn't talk about it at all. So I read this opinion as in dialogue with Ashcroft and saying the Ashcroft dream of the 2005 internet, that we can rely upon parents to protect children from the dangers of pornography online, right? That was just misplaced. I'm not sure that's incorrect. Honestly, I don't think Ashcroft has done a good job of empowering parents to protect kids from online pornography. And I think that the kind of pornography that kids have access to now is something that the Ashcroft court couldn't imagine at the time. So in that sense, I think Paxton has a point. Well, is it enough to overcome the constitutional concerns? Maybe not. And then the last thing I would say is more like, this is like inside baseball in the law, right? The Fifth Circuit has this maddening tendency to fabricate.
This case came out of the case came out of the Fifth Circuit.
The Fifth Circuit, which is the appellate court in Texas and Louisiana.
Yeah, and so they've teed up a lot of these cases for the Supreme Court trying to reverse precedent.
Yeah, that's exactly what I was going to say. Yeah. So the Fifth Circuit has this maddening tendency to create decisions that are facially laughable and transparently designed to create a split with other circuits and force the Supreme Court to reconsider doctrine that the Fifth Circuit wants reconsidered. And it's maddening to me that it worked in this case.
Yeah.
They did it with the USF case, which came down the same day about the non-delegation doctrine. They did it last year with Net Choice v. Paxton. I'm sorry, Moody v. Net Choice.
It was Net Choice Paxton.
It was, yeah. And so, it frustrates me that they got away with it this time.
Okay, very good. Let me just go to the other panel. Your quick thoughts and responses from everything you've heard so far. Kate?
If I want to talk a little bit about, like, the court doesn't talk about the process of age verification itself at all. It's sort of, as David was pointing out, like, they kind of say, like, age verification is a thing now, and it's fine. But the thing is, like, in CDT's brief, we looked at all of the various permissible, like, what we thought might be permissible age verification technologies that could be used to satisfy the Texas statute, and we found problems with every single one of them, either because they could be evaded by minors who are able to, go get somebody else's ID and use it to verify themselves, or because they have an inaccuracy rate that will deny adults, particularly adults in marginalized populations, sorry, my notes, particularly adults in like adults with disabilities, adults who are LGBTQ, particularly trans and non-binary people, and adults of color. They are more likely to experience error rates in a lot of these age verification methods, meaning that it's not just like, oh, you show your ID and it's fine, the way that it might be in a brick and mortar store where also the data disappears because there's no permanence in that transaction. It's very different than that. Every single one of these things has an error rate. That error rate is going to impact both the scope of the law as it applies to minors, allowing minors to access content technically that they shouldn't be able to under the law, or denying adults access to content too, and what happens if you don't have an ID. Lots and lots of people do not have access to government-issued identification that proves their age. So that's another problem. So if you use one of these methods that sort of guesses your age, every single age assurance method, be it facial recognition or the use of transaction data, which is what the Texas law talks about, is a guess. It is a guess at how old you are based on your face or your activity. Oftentimes, if you are guessed to fall in a certain age range, so let's say 17 to 25, the idea then is you get shunted into another process where you verify your age by showing your government-issued ID. And what if you don't have one? And lots of people don't. So this decision, in addition to being the mess that we have all talked about, also will functionally deny people access to constitutionally protected speech that they have a right to see.
Very good. Building off of Kate's point, a real lack of curiosity in the decision about the actual effect of this law, byproduct of not doing strict scrutiny. If you were to pull up your phone right now and in the name of research, pull up Pornhub, you would find that it is blocked because it's not legal in Virginia without age gating, and there's bleed over here. And so mission accomplished, right? Well, no. A lot of pornographic websites are based abroad. They feel no need to follow these rules. I think it's safe to say that if you're taking the entire world as the benchmark, there will be sites that are less safe from everything from a data privacy viewpoint to a how are these performers treated viewpoint to is all of this content consensual? So are you actually exacerbating the problem rather than fixing it? And that's before we get into the existence of virtual private networks, which are really easy to download and hide your geographic location. So it's actually unlikely that this kind of law does much of anything, or if it does anything, actually is harmful. Sticking on the tailoring point, I'm at AEI, so I'm excited to bring up, revealed preferences. The Playboy case I mentioned earlier about adult content on television, and the court said, well, you can't ban the content between 6 and 10 because there's a less restrictive alternative. The problem here was signal bleed, so these channels already weren't available during daylight hours, but the analog signal, you could see like Picasso porn. This was in the 90s.
They scrambled it basically, right?
I was a child in the 90s. I know nothing about this whatsoever.
You never stared at it for a long time? No.
It was an elbow, I promise.
That's why I need the glasses. No.
It was an elbow.
So the less restrictive alternative was that parents could call up their cable provider and say, I don't want this signal bleed, turn it off completely. And like almost no parents did, but is collective apathy about an issue a sign that the state can do more, or is it a sign of collective apathy? So content filtering is available. It's not magic. It could definitely be better, but any parent that is motivated to apply it can control age-appropriate content for their child at the demand side and save all of the adults who don't have children from these restrictions on the supply side. Another point worth making, because we've brought it up, the stigma of viewing pornography. I think it's interesting. No one would mistake me for a judicial progressive, But this is a fascinating decision because it's very rare that you see the Supreme Court take stigma in society as it finds it. Normally, stigma is something the court questions or problematizes, doesn't necessarily rule in favor of the stigmatized side, but it doesn't just say, well, there's animus, so that's a thing, so we need to like accommodate that. I found that to be a very strange line in the opinion. It's also weird, mind you, somebody might avoid age verification not because they themselves find this material to be stigmatizing, but because if enough third parties find it like stigmatizing, you're just going to avoid it as a result of the social consequences, even if you yourself don't have any hang-ups about the content. And then just finally, to wrap these all together, I kind of feel like this is the beginning of the Butlerian jihad. For those of you who don't know, Dune, it's like way in the future and they can travel across the universe, but how can they do that? But they're still kind of humans with relationships that we can all relate to. Why haven't computers taken over and fundamentally transformed the world? Easy fix. We all decided to break the computer somewhere in the past. It's kind of like the thank you for smoking. Like, wouldn't the all-oxygen environment in the spaceship cause lighting a cigarette to blow up? It's an easy fix. We invented the cigarette filter device. Same thing. I digress. Point being, there is this skepticism about technology that is taking hold. We saw it in the death of the AI moratorium recently, and now we're talking about how we're afraid of like weather alteration. I actually think that this decision might be the first salvo at the Supreme Court in a much larger discussion about fear of advancing technology. I think we see it in Justice Barrett's concurrence in the Moody versus Net Choice, talking about like no rights for algorithms, as if that's the problem. It's like humans are always behind these choices. So I think stay tuned. There's going to be a much larger discussion about the role of technology in society at the court.
Excellent. Before we get to Daniel on this one, just to clarify for the students who are here today in thinking about why we keep going back to age verification versus filtering software, because if something can be done without the government mandating it, then there's no need for it, really. And so we're always looking for alternatives. Is there an alternative to an online age verification, right? Is there a way, instead of having this government restrictive law, First Amendment access, if we just used filtering software or other device-based technologies to help parents out, right, then you don't need the regulation, right? This is the American enterprise vision, right? You don't need all that government regulation. It's unnecessary if there's another way of doing it. And under the strict scrutiny test, that's one of the key things. You have to show that the way that the government is going about it restricts no more speech than is absolutely necessary. And so we would have to ask, are there any alternative ways to protect minors that don't restrict as much speech, that don't burden, right, adults' rights to access that speech? And the overall answer is essentially, yes, filtering software. And then Thomas goes into this whole thing, yeah, but it's not effective and the court didn't know back in, whatever, 20 years ago when it first addressed it. So that's why we keep going back to that distinction. Daniel?
Yeah, so I'm not as optimistic as Corbin. And what I mean,
I was optimistic.
And what I mean is, I'm not as optimistic about parents' ability to protect children from stuff they don't want their children to see online. That having been said, right, you're never going to get a perfect calibration. You're always talking about error rates, right? You can either set a legal limit in a way that maximizes adult consumption of content and risks some children seeing stuff they're not supposed to see. Or you can maximize the protection of children at a cost of some adults not being able to see what they want to see, right? Historically, we've set the line on a speech maximization, right? So we'll make sure that what we're doing is protecting adult rights to view content, even if it means like some kids wind up getting around the restriction that we don't want them to have. And that's kind of what the least restrictive means analysis requires, right? That's why strict scrutiny would have been a death knell for the Paxton court if it had adopted that. This is the first decision I think that goes the other way, right? And I think that's super interesting. I also kind of wonder about, as we're riffing on incentive structures, right? Eric Goldman pointed out that if the law applies or not, depending on whether at least one third of your content is pornographic, right? It means that if you're Pornhub, you immediately get a good license for image generating software and generate just a whole bunch of non-pornographic stuff. Put it in a corner of the website so that you have so that your ratio is low enough.
Under 33%. Yeah,
Right. So
yeah.
so under 33% of your content is sexual in nature.
You avoid the law.
And you may end up generating a whole bunch of stuff that kids want to go see, and then they accidentally stumble upon the pornography, and then you're like, you've completely done an in run around what Texas is trying to do.
No, I like that. Any other final thoughts before we move on?
It was weird that, again, I just can't get over the tailoring. This law doesn't apply to social media, and it doesn't apply to search engines. And you can easily find pornography on X, any image search on a search engine. All of the adult sites populate those image search results. And the majority decision says, well, it was reasonable for Texas to think that the 1/3 threshold is what it takes to protect children. And I'm like, well, a minor seeking out pornography only needs enough pornography to satiate that minor's desire, which has nothing to do with the 1/3. The question is there enough on social media or a search engine? Yeah. Which I'm sure the answer is easily yes. So it goes back to this point of just total gutting of the intermediate scrutiny test.
I think I'm really surprised the majority, out of the 6 justices, the majority, there wasn't one who wrote separately to say, I would apply strict scrutiny, but strict scrutiny is met here. That's sort of the intellectually honest way of getting to the result that the majority wanted to get to, and I was surprised it was like zero voice for that position.
I'm sorry.
They instead went the other way and said, well, wouldn't you then have to apply strict scrutiny in the real world, and wouldn't that be a problem for age verification at brick and mortar stores, which I thought was kind of curious, both A, because the Supreme Court, when it's in a different mood, has no problem saying, oh, well, the decision we decide today might be in tension with this other precedent, but nobody's asked us to overturn that precedent. That's not what's before us, so we're going to follow the precedent that actually is directly on point, which in this case, you guys don't need to like know the names, but here would be like Ashcroft clearly applies. Ginsburg is like this other context. And normally, Mr. Burkean incremental minimalist Chief Justice Roberts would say something like, well, Ashcroft clearly applies. We'll deal with those other problems tomorrow. That's the first problem. And then the second problem being, as Justice Kagan was very good at pointing out, least restrictive means if there's no better way to do it, you're fine. So in the brick and mortar world, maybe it is the least restrictive to say, look, you glance at the ID, you're not going in the back and making a Xerox of it. A lot of people are very clearly over age and don't even need to be checked at all. So like there's no better way to do it. But there's no equivalent easy age verification in the online world. So it meets strict scrutiny in brick and mortar and not online. So there were multiple ways to not go this path.
Yeah. I think if I were to just sum it up for the students too, you shouldn't take away, well, because the liberal justices would have applied strict scrutiny. It's not like they're pro-porn, right? This is not what we're talking about. It's really a First Amendment analysis, and that's really what we're deciding here is like what standard of review, how rigorous should it be to pass this threshold? And so another thing too, it's kind of interesting that we've all been hyperly critical, not hyperly, but very hyperly critical of the majority's approach, the conservative majority's approach. And so sometimes on free speech issues, it really doesn't matter whether you consider yourself politically conservative or politically liberal. I think First Amendment issues, people take different sides, and so it's important. You can't really stereotype people when it comes to how they're going to go in a free speech case. All right, we've got what I hope to do now is go about 9 or 10 minutes on the other cases. I'm going to start out with Kate on TikTok versus Garland, which was a January decision by the United States Supreme Court, in which the Supreme Court, again, applied intermediate scrutiny, and one of you pointed that out already, this lesser standard of review to uphold this ban that the Biden administration had adopted. Congress had overwhelmingly approved it, bipartisan, as I recall, right? And said basically, it's this Foreign Adversary Controlled Applications Act, and China being the foreign adversary, you either, China, have to sell it, get rid of it, or American companies that service it, right, provide different support for it, they can't do business with it anymore. The Supreme Court upheld that law and said that's fine. We know that President Trump has extended it a couple times, and I'll go to you, Kate.
Yeah, sure. So about a year ago, a little before now, but in the spring of last year, Congress presented this bill, a bipartisan bill that was suddenly saying, like, TikTok and any other foreign adversary-controlled application as defined by the president in the future must divest itself of its foreign adversary ownership, including any ownership over speech-related algorithms that deliver content on those platforms, or all entities providing services to those applications, to those foreign adversary-controlled applications, must cease providing those services. So TikTok should no longer be available in app stores. Content delivery networks, for example, aren't supposed to continue to provide services to TikTok, which makes TikTok work a little bit better and a little faster within the United States. And the immediate reaction on the part of many people was, this is unconstitutional. You're going to ban access to an entire speech platform that's currently used by 170 million Americans. But the Congress's response was, no, we're not banning it. We're just requiring divestiture. We just don't want a foreign adversary to control it anymore. And
we're just stealing it.
Yeah, yeah. We're just legally requiring we own it. And then like this bill rocketed through a Congress that, in a bipartisan fashion, through a Congress that has not been able to agree on many things at all, even when controlled by one party. Rockets through Congress, gets signed into law. The law says it takes effect in 270 days. It just so happens, and like because TikTok is named in the law as one of those platforms, it just so happens that it will take effect on January 19th, 2025, which is the day before President-elect Trump will take office. At this point, everybody sues. So TikTok US sues, and a bunch of TikTok users sue, saying this law is a clear violation of our First Amendment rights. It will prevent TikTok US, which has First Amendment rights, from speaking within the United States going forward. It will prevent all of the TikTok users, some of whom use the application for their livelihoods, from using the speech platform of their choice. There are many cases which say that when Congress forecloses an entire avenue of speech, that has significant First Amendment concerns and should not survive, and should, like strict scrutiny, as we've already discussed, should apply, and the law should not survive. Because of there's also a part of the statute which permits the president to extend the ban, to extend the implementation of the ban for one 90-day period if the president certifies to Congress that this is because there is a qualified divestiture that's in the offing, basically, like this is already happening and it's going well. So we're going to give it time to close. And so everybody says this is unconstitutional because of a weird thing in the law. It goes directly to the DC Circuit instead of to the district court to begin with. The DC Circuit says strict scrutiny applies, and somehow this survives strict scrutiny. I'm not going to get into that. It was a wild decision, but we don't have to go into that. It immediately goes to the Supreme Court, and on a truncated schedule, the Supreme Court eventually, in early January of this year, issues what is called a per curiam opinion, which means the opinion is unsigned. So the entire court speaks as one, and there are two concurrences, one from Justice Sotomayor and one from Justice Gorsuch. The opinion is, as Clay said, it upholds the law based on intermediate scrutiny. And what the court does, I think it has like four main holdings. What the court does is it says, this law is not actually about speech, it is about ownership, and there are significant national security concerns at issue. Congress has determined that this app is owned by a foreign adversary. We give significant deference to that. And it's not about anything that TikTok has said. We know that because TikTok can't change its speech and avoid the law. So this isn't really targeting speech, it is targeting ownership. But we're going to apply First Amendment scrutiny anyway because it is going to affect the speech of 170 million people, so we do care about that. The court then goes on to say this is a content-neutral law. So that's the second thing they say. They say this is a content-neutral law because it's not about what any, like, what speech is on TikTok at all. This is a bit of a fake on the part of the court, in my view. Well, for one thing, the idea that ownership doesn't matter is a fake from a First Amendment perspective, because ownership very much does matter, and anyone who continues to use X and used to use Twitter knows that it does. Because the messages, the design of that application and the way it delivers speech now, you either like it so much better or you dislike it so much more, right? Like, it is very different. So ownership does matter. Requiring someone else own TikTok would and will, assuming there is an ownership change the speech mix on that platform in some way or another, because there will be somebody else's values that are dictating how it happens. So second fake is that this is a content neutral law. So the Congress had two justifications for passing this law. One, data. They didn't want, there was a Chinese requirement that any Chinese-owned company provide data to the Chinese government upon request. TikTok would be subject to that requirement. They would have to turn over all of their data if the Chinese government asked for it. That was a data privacy concern. The court said that was content neutral. But the other thing that everybody who supported this law and voted for it said was that they were concerned about Chinese propaganda being distributed on TikTok, and the way that the Chinese government might have control over the mix of speech as it's delivered on TikTok. So the court ignores that and focuses instead on the data privacy provision, and then says that the law is content neutral and justified in a content neutral way. Protecting this data is absolutely a compelling interest, a national security concern. And then it goes on to say, and this is narrowly tailored because the concern is ownership, and it specifically targets ownership. No one cares what anybody says on TikTok. Everybody can continue to enjoy their TikTok and say whatever they want on TikTok or whatever TikTok allows. All Congress cares about is ownership, and the law targets that specific ownership and attempts to address the national security concerns. Then the court goes on to say, also, yes, there was a mixed justification. They finally admit that there was a mixed justification, but we don't have to decide that case right now. We don't have to decide whether it's permissible, whether control of an algorithm raises speech concerns, or forcing someone else to control a speech algorithm raises speech concerns under the First Amendment. We're not going to do that. And so we uphold the law. Congratulations. Then we have Justice Sotomayor, who says, you don't have to assume without deciding that that First Amendment scrutiny is supposed to apply here. It absolutely does, and intermediate scrutiny is right. I agree with everything else. And then you have Justice Gorsuch come in to make a couple, I think, interesting and important points. The first is, he says, it's good that the court did not address the speech-related justification for the law. In his view, one person's content manipulation is another person's editorial control, very clearly a First Amendment issue, but because there was a content-neutral justification, it's fine not to have dealt with that this time. But if any law is ever justified just on the basis of the control of a speech algorithm, he would have significant concerns. All well and good, but everybody now knows that you just need to find some other justification, and the court will use that one. And then the second thing he says is he praises the court for not relying on secret evidence. The government had submitted to the court evidence of Chinese influence over TikTok, or what they said it was, but it did not provide that evidence to TikTok at all. So the court declined to take a look at that, and Justice Gorsuch said that's good because secret evidence is bad, and parties should know what they are being accused of so that they can answer for it. And then the last thing Justice Gorsuch says, which bleeds into his justification for upholding the decision, is the standards of scrutiny actually aren't all that helpful. We spend a lot of time talking about them, but sometimes the amount of time we spend talking about them actually obscures what we're trying to figure out, which is this law justifiable under the Constitution? And that's interesting, especially in light of, on one hand, I kind of agree with him. I do think sometimes we get too much into which category does this fall into. But on the other, he's saying this in the context of an opinion that is very clearly, to my mind, contributing to the erosion of the intermediate scrutiny standard, which to my mind, has been further eroded by FSC versus Paxton, which we just talked about, but in this case also was eroded. Like the court just glossed over the 170 million people who would no longer have access to the application of their choice, who would lose their businesses, in favor of saying, this is like national security is a justification and we're not going to think too hard about it. Changing ownership has nothing to do with requiring a change of ownership has nothing to do with free expression. All kinds of things are in this opinion that, you know, if we think about it going forward, or if we ever cite it again, which Corbett and I were talking about, which maybe we won't, because the court was very clear that, like, we're deciding this case very quickly, we're trying to cabin it just to these facts, but it could create a lot of mischief going forward. And anyway, and so we get this decision, it upholds the law. Congress immediately says, oh no, like, we're gonna ban TikTok. We didn't mean to do that. We just meant to get divestiture. We're gonna pass something that gives an extension. They never pass it. TikTok shuts itself down. President-elect Trump tweets or posts wherever, I think truths, he's on Truth Social now, right? Truths that he's gonna save TikTok. He's gonna issue an executive order day one that extends the deadline for finding a new owner. And TikTok immediately turns itself back on. That executive order does not comport with the law in any way at all whatsoever. So currently, all of the companies providing services to TikTok are in violation of this law, even though the president has directed the DOJ not to enforce it. This is extraordinary. They are all in violation of this law. We now have evidence that what essentially the Attorney General has said to these companies is, you are not in violation of the law, and you should and can continue to provide services to TikTok. But again, that is not true. The statute is very clear regarding the circumstances under which an extension of like TikTok's time in this country could be granted. That standard has not been met, and there has been no certification to Congress, and yet we're all still pretending that this law doesn't exist. So Congress passed a law, Supreme Court upholds it under the First Amendment, under reasoning that I found very difficult to accept, and yet still we all have access to TikTok, and the law isn't being enforced at all. So that to me is a really extraordinary circumstance, and we continue to await what will happen.
That's a great, no, it's a great synopsis of it all. I pointed out yesterday, AAI's Jack Landsman Goldsmith had a great piece about this, about how what Bondi as the Attorney General is doing is really illegal. Basically saying, no, you're not violating this, and that doesn't exist. The executive branch does not have that power, essentially, to say that Congress passed this law, as he said, bipartisan, overwhelming support, and the president doesn't really have that authority, or his attorney general, to make that choice. But that's what's happened here. I know we're short on time, but we might not even get to the last. I don't know. But you have any
I'll
thoughts?
try to catch us up on mine then. Yeah. As of 3 months ago, I am a member of the TikTok Content Advisory Council. So full disclosure, my thoughts have not changed, and I am not breaking any law as far as I know. Okay.
Well, TikTok isn't breaking any laws, is it?
Exactly.
It doesn't prevent TikTok from doing anything.
But here's the thing. There's so many thoughts on TikTok, but I will get to the point. Like, attention, young people of America, who's a lot of this audience. This law is aimed at you. It is not aimed at me. It's not aimed at Daniel or Kate or Clay or Shane. It's not aimed at boomers who apparently have like a totally healthy relationship with technology. The legislature was afraid that you are fragile little things that will be exposed to ideas that are dangerous and will get into your head and infect you like a hypodermic needle, and then you will believe bad things. That is what drove this law, okay? Now, there's all kinds of problems with, is it actually true that the algorithm is manipulated or whatever? Like, I go on Douyin in China and it's Jet Li kicking people in the face It is not true that they are actually trying to feed STEM videos over there and trying to get you to commit suicide over here. I digress. We are in a republic where we are considered citizens who can make up our own minds based on the ideas we are exposed to. This law was about legislators thinking that is no longer true for you. They are afraid of you. That was the key to this case. And to say something against TikTok's interests, I thought the great tragedy of this case was that they argued first. I don't know why TikTok got up at the podium first. The case is not about TikTok. The case is about you. And Jeffrey Fisher got up second to argue for the rights of users and the fundamental First Amendment principle that you guys get to be exposed to ideas and make up your minds for yourselves as freaking adults in a constitutional republic, and Congress tried to take that away from you. That was the key to the case. Now, I don't know if Fisher going first would have changed things. Maybe the Supreme Court was going to do what it was going to do, but that really got buried, and it played no part in the opinion whatsoever, even though it is the fundamental part of this case, okay? Weirdly, you can still access TikTok because the national security case was bogus all along. I don't have any other explanation for how this app still exists, but the fact that it was a trumped-up rationalization the whole way through. I'd be a little embarrassed if I was on the Supreme Court and I rubber stamped this, and here we are. They're in a difficult situation when people yell national security at them, but nonetheless, I would feel a bit had. And the only silver lining I can glean from this is I hope the next time the government hollers national security, the Supreme Court justices will maybe be a little less naive.
If I can add to this before getting to Daniel at this point, two big picture concepts we're looking at. One are users' rights, and so that's what we're talking about, the users' rights of TikTok to speak, but also the right to receive speech, right? And so we haven't really talked about that, but under the First Amendment, Congress shall make no law abridging freedom of speech. But there's also an unenumerated or implicit or implied right to receive expression, an expression that's lawful. So that definitely came through in Free Speech Coalition versus Paxton. It was about the right to receive speech as adults that you have a right to do. But we're talking here on TikTok that not only should you have the right to speak, but also the right to receive other people's speech and views. And so that's important when you're kind of thinking about First Amendment rights. It's not just a right to speak, it's a right to receive speech. Daniel, look at you.
Yeah, no, I think Corbin's exactly right. That I was on record as saying like the biggest mistake in the evolution of litigation in that case was the combining of the TikTok suit and the TikTok users suit, because the TikTok users I thought had a much stronger case, and they just got lost in the shuffle. In the shuffle. So lots to say, but I'll limit myself to a couple things. One, the court decides this on content neutral grounds because it says we think Congress would have passed this just on the data privacy rationale alone. Like this idea that TikTok hoovers up your data and that can have intelligence value to the Chinese government. And that's sufficient. So we think, independent of this like concern about what content TikTok is carrying, that's enough. And so we'll decide it on intermediate scrutiny grounds. I'm not sure that's correct. Representative Gallagher has gone on record as saying the TikTok bill that actually like stalled in Congress for a while. And what got it the votes to get over the line was October 7th, right? And the proliferation of pro-Palestinian videos that were popping up afterward that enraged enough of the holdouts in Congress to provide the votes that got the bill over the line in the House. That tells me that it was a content-based decision that got to the majority, right? Content played a part in it. The other thing is, yeah, I think it's really problematic that the government has all this national security information. They rush the court through. Justice Gorsuch's concurrence makes very clear he's uncomfortable with how we've rushed it, but it's important enough we need to make this get done. And then we get the decision, and in my sense, it's like the worst of all possible worlds. Like I'm not a TikTok stan. I see the case for national security. I totally understand. Like if TikTok knows information about this person and that person and can put them together, like that has intelligence value that they could use, right? I get that. I wasn't pro TikTok, I was pro First Amendment. And so now I'm in the worst possible outcome where we've got this decision that harmed First Amendment values without meeting the national security concerns because TikTok is still out there and available.
You know, looking at this, we're all critical of both cases and both decisions. It looks like we're very anti-Supreme Court. For a long time, the Roberts Court was thought of as being very pro-free speech, at least in certain contexts, not in all. But we think about the violent video games case. That was called Brown versus Entertainment Merchants Association. The court protected minors' access to purchase violent video games without having to get parental consent. Snyder versus Phelps, the Westboro Baptist Church. Has anybody heard of them? They would go to right. And so the Supreme Court protected their right.
Not a church.
What?
Not a church.
Not a church. Yeah, the WBC. So they had an odd belief system, and they would show up at funerals for American soldiers who were killed in Afghanistan and Iraq because they believed they were killed due to Americans' tolerance of homosexuality. So there's a rational belief system, but the Supreme Court nonetheless protected their right to engage in highly offensive speech. But both cases we've talked about today are really the flip-flop of that. It's not a protective free speech court. And so it's really much more selective in terms of how it goes down that path, what it's going to be free speech protective and not on those various issues.
It's funny how these things evolve, right? So Heritage has gone way out in supporting this kind of stuff. And then we're at AEI, the heart of neoconservatism. I think Irving Kristol would be really appalled that we're having this talk. He believed pornography brutalized people, and I find it very hard to see him supporting our position in Paxton. So it's fascinating the way to live is to maneuver in Buckley's line.
Any other thoughts? We don't have much time. How about we just take the jawboning? Is that okay for you? So jawboning is what we might refer to as informal censorship. Formal censorship would be passing a statute or passing a law, and that law might say you can't engage in free speech. When we talk about jawboning, we're talking about the government. Verbal arm twisting is one way to look at it, applying pressure to private entities to try to get the result it wants in not allowing some speech to come out. And the court, long story short, in a case called NRA versus Vulo last year, had kind of created or affirmed a test from a prior decision, Bantam Books. But all that suggested is there's really a dichotomy. We talked about dichotomies, right? Lawful pressure, lawful persuasion, but unlawful coercion, right? And you can't coerce. And then that got us to a case last term called Murthy versus Missouri, which involved the Biden administration's jawboning of social media platforms, the Facebooks and the YouTubes of the world, to take down conservative, right-leaning, right-tilting content about things like mask mandates and COVID-19 policies, shutdowns, school shutdowns, and election fraud. And the Supreme Court only punted on the merits of that case. They said that the majority, at least, said that the plaintiffs didn't have standing, we won't go into that, to raise these, to get to the substantive merits, so they punted. So what we're going to talk about right now, and Corbin's going to take the lead on this, and I'll let you go over it, but might we see another future jawboning case involving other types of informal efforts by the government to try to change or censor speech?
So in the name of time, I'll try to just set this up very quickly and then throw it out to Kate and Daniel because I'm interested in their thoughts. Murthy, I would quibble with the notion that the court punted. The plaintiffs lost because they weren't the victims of what they claimed to be the victim of. The Biden administration was jawboning social media platforms about speech primarily involving COVID. I'm not glad that they did that. I don't support them doing that. But the tech platforms are big boys and largely did their own thing and made their independent decisions about their content moderation. And so the people who were complaining, oh, I was silenced by the government, there just wasn't evidence for that. They weren't able to make the causal connection. Which both cast some light on the whole censorship of conservatives thing being overblown about social media, but also starts to get us towards a big problem. The government jawboning party A often leaves no party B able to object to that jawboning. So standing, we do need to get into it very briefly. What it means is that when there's a lawsuit, I need to have a vested interest in the lawsuit, and the person I'm suing needs to have a vested interest in the lawsuit. I can't just show up and say, I'm really annoyed that the government did this thing way over there that doesn't really concern me, and I want to sue about that. You can't do that. And so this topic started when we were discussing it as, will there be another jawboning case? And now my attitude is more, what do we do with this problem from hell? Because what's going on now, some of the same actors who were really jazzed about this job owning problem in the prior administration are now gleeful job owners themselves. And so
Sounds like an indie group, the Gleeful Job Owners.
the gleeful job owners might actually sound like one of our age gating issues.
Yeah. The Free Speech Coalition will handle that.
Gonna let that sit there. The Federal Communications Commission and the Federal Trade Commission are going after parties that have crossed President Donald Trump in some way, or have engaged in their own speech rights toward social media in some way. But all we see is caving and capitulation all the way up to the horizon. So Paramount and ABC, these companies that say aired interviews that they edited in a way that Donald Trump was unhappy with, not even in a way that was somehow false or fraudulent, are paying out money to get the government or Donald Trump himself to go away rather than fighting for their rights. Advertising agencies are getting attacked by the FTC for exercising their First Amendment right of free association and free speech in saying that they don't think advertisers should pay ad dollars to put their ads on certain social media platforms, such as X, because there's speech on those platforms that they find hateful. That's their First Amendment right. And yet, a merger recently occurred with a giant ad agency, and it caved and agreed to conditions that would violate the First Amendment if they chose to fight it, but because they want their merger to go through, they just went ahead and followed it. So if you're an outsider looking in, you're seeing what are in effect violations of the First Amendment that arise from, if you want to call it job owning, or in some of these cases just like outright extortion, and yet who has standing to sue, and will this dynamic continue, and how do we break this logjam? I hand it to you.
So I guess what I would say is, like a lot of things, people say, Trump's a fascist, Trump's not doing anything different than anybody else did before him. He's turning it to 11, right? Trump takes what's come before and turning it to 11. This pressure that we see is not new. We used to call it regulation by raised eyebrow, right, in the FCC. Like, you're not, it looks to me, broadcasters, like you don't have enough children's programming, right? And it's not that the FCC could go force broadcasters to increase the amount of children's broadcasting they had, but if they didn't, they might find themselves subject to regulatory scrutiny in other ways, right? Because they're in a repeat player game. Comcast bought NBC Universal, and one of the conditions, the FCC said, well, we could approve this merger, we could say no, but we're going to say yes only if you agree to abide by net neutrality voluntarily for the next 10 years. At a time when the FCC, it wasn't clear whether they had the authority to impose net neutrality rules or not. The Federal Trade Commission has made an entire industry out of enforcing privacy rules based on consent agreements, that very few of which have ever been tested in court, right? So you have a data breach, the FTC sues you, and then they offer to settle. But one of the conditions of settlement is you can't challenge the settlement in court, and therefore ask a court to review whether the FTC can even be exercising jurisdiction in this space. And for like 15 years, they built an entire body of data privacy rules entirely upon these consent decrees. So it's an inherent problem with entities that are in a repeat player game with the government, that they can use leverage in situation A to get you to voluntarily agree in situation B to something they can't actually force you to do. I think this is another version of that. It's just a much louder and more obnoxious version. Mm-hmm. And this doesn't say it's not problematic. It is.
Thank you. So something Daphne Keller has written about with respect to job owning. She has an article called 6 Things About Job Owning. As somebody who both now studies it, is a First Amendment expert, but also was job owned when she had a role at one of the social media companies, everybody does it. So along the lines of what you were just saying, everybody does it. But in this particular circumstance, that the FCC and the FTC, but also a lot of what the State Department and other actors who have authority over non-citizens' entry to or continued presence within this country are doing. The government is making it very clear what speech it doesn't want to hear, and that might be speech that is critical of President Trump. It might be speech that is critical of the government of Israel. It might be other types of speech that the government is now categorizing as anti-American. They're making very clear that there are categories of speech that they don't want to hear, and they are using every lever possible in order to create examples of people who have engaged in speech that the government doesn't like and are punishing those people sort of in the open so that everyone else understands that they shouldn't say those things. So if you want to be a student at Harvard and you are a foreign national, you are currently probably scrubbing your social media accounts or deleting them entirely, though the State Department has now said that they may consider that evidence of evasion of the evaluation for your visa. I think that's pretty extraordinary. Like, a lot of the examples that we've talked about so far are like, we're trying to achieve what is, generally speaking, people might disagree with it, but maybe a legitimate end. Even if we couldn't necessarily, under our existing legal authority, impose it. So like the privacy by consent decree, like there are a lot of First Amendment questions about how to regulate privacy, for example. There's a lot of questions about the scope of the FTC authority. The FTC made a years-long plan for how it was going to assert its FTC Section 5 authority, which prohibits unfair and deceptive trade practices, to say, like, if you have certain privacy policies, you must abide by them, and if you violate them, that's an unfair and deceptive trade practice. I sort of understand that. This, to me, is very different, especially in how clear the administration is being in so many different ways about the type of speech it does not want to see produced anymore, or you will experience consequences as a result, whatever consequences they could think of. They could be directly related to the speech that you're engaging in, or somehow ancillary. If you want something from the government in the merger context, for example, you're going to get asked to do something that has nothing to do with your merger and has nothing to do with the competitive nature of the merger either, right? So I think that's pretty extraordinary, and definitely, like, maybe it is a difference in degree, but it's such a gigantic degree.
And so the levers of power, and we'll go to questions next, the levers of power that we're really talking about are how could Trump use the FCC and the Federal Trade Commission in getting Andrew Ferguson and Brendan Carr basically to help out in those battles. For whatever power they may have or not, and ultimately whether they're resolved or not, it doesn't really matter. We've started this process of pressure on you and you're going to feel it. So we might not have standing, right, to challenge it in court, but the pressure enough is going to change you. So at this stage, we got about 9 minutes left. We will take any questions. I don't know who has the microphones over. We'll go one right there, and we'll move over there. He's got it.
Yes. Hello. This is a question on the TikTok ban thing, and specifically on the weirdness of not enforcing the law. One comparison that I haven't heard yet, and I'm not certain if it's just an entirely different case, if it's an entirely different legal problem, and that is with the whole question of marijuana legalization and the fact that, federally speaking, marijuana is still very much illegal. And there were times, for example, during the Obama administration, where the AG held off a lot on enforcing certain laws, on marijuana possession. How exactly was that justified, and is there a parallel between that and the just completely ignoring the TikTok ban law?
Can I answer in one sentence? There's a distinction between exercising prosecutorial discretion, even if sort of sweepingly and cynically, and what you see in the letters that Pam Bondi sent to the companies engaged with TikTok, which say the president can deem it not illegal, and that's the divide.
I would add one thing to that, though. Like, one of the things that's extraordinary to me about the TikTok ban is the fines that could be incurred as a result of this are astronomical. It's $5,000 per user that can access TikTok while the ban is supposed to be in effect. And the statute of limitations is 5 years. So even if we were under a declination of the use of prosecutorial authority, that is a thing that many prosecutors have to do because they can't prosecute every single case. You also, if you're subject to the law, have to trust or have to have some assurance that in 5 years, when there's somebody new, you will still be okay.
That's where the letter comes in handy, right? It's
Yeah, exactly.
Strong evidence that sort of, at most, you have a strong entrapment defense or something along those lines. I'm not a criminal law
exactly.
guy, but not entirely unprecedented. Again, Trump's just turning everything up to 11, right? When Obamacare was adopted, there was a 1-year statutory deadline by which I think it was the website had to become effective or something along those lines. And it was clear as we approached the deadline it wasn't going to make it, and Obama just said, we'll just extend that out 1 other year. Same exact scenario, right? Different stakes perhaps, but again, not unprecedented, just louder and more obnoxious.
The reference to 11 is Spinal Tap, by the way. Anyway, all right, go ahead.
They all know this.
Okay. Well,
They should.
Courtney Radge from the Center for Journalism and Liberty. It's interesting. So I worked with CDT for many years on free speech issues, and in the past there was a lot of concern about what we call jawboning, or these indirect referrals, internet referral units. Back then it was around terrorism content, which again very ill-defined. Then COVID content, all of this sort of thing. And so it feels like there has been a shift now in a lot of the community to go from, we don't like the idea of the, government trying to jawbone or influence the content that's taken down. That shifted, during administration. So it feels like a little bit of wavering in the community. And I wonder, to what extent should we be looking to solutions such as designating social media platforms, search platforms, particularly dominant players, as common carriers, or as having obligations akin to other forms of kind of publicly accessible infrastructure that holds itself open to everyone, similar to a railroad, a telephone, an internet service provider, and essentially say you don't have, because you provide this service, as a common carriage, you don't get to have the same level of First Amendment rights, right? So we did this for broadcasters, we did this rather for cable and satellite operators, and said you must carry local content if requested, because there's a public interest in that, and that was found not to violate the First Amendment. Same with many other common carriage provisions, and that was also a case in the court. So could you talk about that, as whether you think that should be one of the solutions that we're looking here, so that we take out some of that pressure point to even enable the government to kind of impose jawboning?
I guess that's for me to start. Ari,
He's egging me on.
Corbin, you want to go for it quicker than.
I don't know if I could think of a better way to exacerbate the problem, in my mind. More government control actually means more government levers to informally jawbone, whatever the formal rule may be. And that's putting aside the fact that that formal rule in the context of social media would turn social media platforms into sewage pipes akin to Gab.
Kate? On that?
Sure, on that particular
or Ari,
point.
do you want to know? Okay, go ahead.
No, I'm happy to. For one thing, like we did file a brief in the Murphy versus Missouri case, and our take was, Bantam Books is the right standard, and if there is a close case, the tie goes against the government. The government should lose if the case is close. On the common carrier question, I share Corbin's concerns that the creation of a kind of must-carry obligation for large social media platforms would be a sort of avenue by which content moderation could actually be subject to even more jawboning by motivated actors that want to force certain speech to stay up, where human rights assessments might counsel that they be taken down. or otherwise restricted in their distribution in order to ensure that everybody is able to participate in online platforms that are, generally applicable. What I am interested in is seeing more platforms that allow more people to engage and control their own experience. I am interested in seeing the continued development of Blue Sky, for example, which allows people to build off of it to create experiences that they are more interested in and that better suit them. How do we incentivize the democratization of the ecosystem itself? That's what people continue to say that they want. But I don't necessarily think that forcing platforms to be common carriers is the best way to do that, because to me it creates the incentives that Corbin's concerned about, and also creates a situation in which platforms don't know what they can take down, and that is, to me, probably problematic, not just under the First Amendment, but as a policy matter.
Yeah, unfortunately, we didn't get to our last one, which deals with this. What's happened since Moody versus NetChoice was decided, and the cases have been sent back down. But that case, at least a majority of the court did make clear that platforms do have a right of First Amendment editorial control and discretion to determine for themselves what content goes on and what content goes off, and where it's placed and where it's prioritized, right? So at least a majority of the justices got that result. Alito would say it was in dicta, but it truly was there, that the First Amendment does protect just like a newspaper would be. It's a rough analogy, but the court went there at least as to the YouTube homepage, at least as to the news feed that you would get off of Facebook. So we are exactly at time. I want to thank all of you in the audience. Hopefully you learned something about TikTok even. So that was good. I want to thank the panelists, and I want to thank Shane. I also want to thank Julia Torres and Kate Van Kampen for organizing this and pulling us all together and kind of herding us as cats up here on stage. So thank you very much.